Okay, I'm reading the Truth in Lending Act out of the Code of Federal Regulations, and that's online on reading through Subpart F, Special Rules for Private Education Loans. And I'm going to start with Section 102646, Special Disclosure Requirements for Private Education Loans. And coverage. The requirements of this subpart apply to private education loans as defined in 1026.46b5. A creditor may, at its option, comply with requirements of the subpart for the extension of credit subject to 1026.17 and 1026.18 is extended to a consumer for expenses incurred after graduation from law, medical, dental, veterinary, or other graduate school and related to relocation, study for a bar or other examination, participation in a internship or residency program, or similar purposes. Number 1, relation to other subparts in this part. Except as otherwise specified, provided the requirements and limitations of this subpart are in addition and not in lieu of those contained in other subparts of this part. Number 2 is reserved. Letter B, definitions. For purposes of this subpart, the following definitions apply. 1. Covered educational institution means an educational institution that meets the definition of an institution of higher education as defined in paragraph B2 of this section, without regard to the institution's accreditation status, and 2, includes an agent, officer, or employee of an institution of higher education. An agent means an institution-affiliated organization as defined by Section 151 of the Higher Education Act of 1965, or an officer employee of an institution-affiliated organization. Number 2, under letter B, institution of higher education defined has the same meaning in sections 101 and 102 of the Higher Education Act of 1965 and the implementing regulations published by the Department of Education. Number 3, post-secondary educational expenses means any of the expenses that are listed as part of the cost of attendance as defined under Section 472 of the Higher Education Act of 1965 of a student at a covered educational institution. These expenses include tuition and fees, books, supplies, miscellaneous personal expenses, room and board, and an allowance for any loan fee, origination fee, or insurance premium charged to a student or parent for a loan incurred to cover the cost of the student's attendance. Number 4, preferred lender arrangement has the same meaning as in Section 151 of the Higher Education Act of 1965. 5, private education loans means an extension of credit that, room numeral 1, is not made, insured, or guaranteed under Title 4 of the Higher Education Act. Room numeral 2 is extended to a consumer expressly in whole or in part for post-secondary educational expenses, regardless of whether the loan is provided by the educational institution that the student attends. Room numeral 3 does not include open-end credit or any loan that is secured by real property or a dwelling. And room numeral 4 does not include an extension of credit in which the covered educational institution is the creditor if, letter A, the term and extension of credit is 90 days or less, or letter B, an interest rate will not be applied to the credit balance and the term of the extension of credit is 1 year or less, even if the credit is payable in more than 4 installments. That's defining private education loan. Letter C, form of disclosure is clear and conspicuous. The disclosures required by this subpart shall be made clearly and conspicuously. Number 2, transaction disclosures. Room numeral 1. This is all under the form of disclosures. The disclosures required under 1026.47 B and C shall be made in writing in a form the consumer may keep. The disclosures shall be grouped together, shall be segregated from everything else, and shall not contain any information not directly related to the disclosures required under 1026.47 B and C, which include the disclosures required under 1026.18. Room numeral 2, under number 2, transaction disclosures, the disclosures may include an acknowledgement of receipt, the date of the transaction, and the consumer's name, address, and account number. The following disclosures may be made together with or separately from other required disclosures: the creditor's identity under 1026-18A, insurance or debt cancellation under 1026-18N, and certain security interest charges under 1026.18O. The term finance charge, this is Roman numeral 3 under transaction disclosures. The term finance charge and corresponding amount, when required to be disclosed under 1026D, and the interest rate required to be disclosed under 1026-17B1, I, and C1 shall be more conspicuous than other disclosures except the creditor's identity. Number 3, electronic disclosures under the form of disclosures. The disclosures required may be provided to the consumer in electronic form, subject to compliance with the consumer consent and other applicable provisions of e-sign. The disclosures required may be provided to the consumer in electronic form or on or with an application or solicitation that is accessed by the consumer in electronic form without regard to the consumer consent or other provisions of the e-sign act. The form required to be received under 1026.48e may be accepted by the creditor in electronic form as provided for in that section. So this is saying disclosures require the consent and other applicable provisions of e-sign, but the disclosures are that covered by 1026.46a coverage doesn't need consent if it be on an application. I suppose that makes sense. Notwithstanding paragraph D1I of this section, for a loan that, wait, did I miss timing of disclosures? Yes, I did. Letter D, timing of disclosures. Number 1, application or solicitation disclosures. Roman numeral 1, the disclosure required under 1026.47a shall be provided on or with any application or solicitation. For purposes of this subpart, the term solicitation means an offer of credit that does not require the consumer to complete an application. A firm offer of credit, as defined in Section 603I of the Fair Credit Reporting Act, is a solicitation for purposes of this section. So what I just read earlier about e-sign does not apply to the coverage section of this 1026.46. It applies to something I haven't read yet in 1027, letter A, 1026.47, letter A, which I'm going to read shortly because I'm almost done this section. Let's just get through the timing of disclosures. For purposes of the subpart, the term solicitation means an offer that does not require a consumer to complete an application. A firm offer of credit, as defined in the Fair Credit Reporting Act, is a solicitation for purposes of this section. And Roman numeral 2, the creditor may, at its option, disclose orally the information in 1026.47a. I'm just going to read now what the hell that is. Content of disclosures, A, application or solicitation disclosures. So there you go. Thank you. Where are we? The creditor must provide the disclosures or place them in mail no later than 3 business days after the consumer has applied for the credit, except that if the creditor either denies the consumer's application or provides or places in the mail the disclosures in the next section of 47 no later than 3 business days after the consumer requests the credit, the creditor need not also provide the 1026.47a disclosures. Roman numeral 3, notwithstanding paragraph D1I of this section, for a loan that the consumer may use for multiple purposes, including but not limited to post-secondary educational expenses, the creditor need not provide the disclosures required under 1026.47a, which is an application or solicitation for a private education loan, which would probably be the case if someone was applying for like a second mortgage / home equity product that was going to be used for education as well as other purposes. Number 2 under D is the approval disclosures. The creditor shall provide the disclosures required by 1026-47B before consummation on or with a notice of approval provided to the consumer. If the creditor mails notice of approval, the disclosures must be mailed with the notice. If the creditor communicates notice of approval by telephone, the creditor must mail the disclosures within 3 business days of providing the notice of approval. If the creditor communicates notice of approval electronically, the creditor may provide the disclosures in electronic form in accordance with 1026D3. Otherwise, the creditor must mail the disclosures within 3 business days of communicating the notice of approval. If the creditor communicates approval in person, the creditor must provide the disclosures to the consumer at that time. So now I'm reading 1026.46D3 I just referenced. It's called final disclosures. The disclosures required by 1026.47C shall be provided after the consumer accepts the loan in accordance with 1026.48C1. Number 4, receipt of mail disclosures. If the disclosures under paragraphs D1, D2, or D3 of the section are mailed to the consumer is considered to have received them 3 business days after they are mailed. Letter E, basis of disclosures and use of estimates. Number 1, legal obligation. Disclosure shall reflect the terms of the legal obligation between the parties. Number 2, under E, basis of disclosure and use of estimates. Estimates. If any information necessary for an accurate disclosure is unknown to the creditor, the creditor shall make the disclosure based on the best information reasonably available at the time the disclosure is provided, and shall state clearly that the disclosure is an estimate. Letter F, multiple creditors, multiple consumers. If a transaction involves more than one creditor, only one set of disclosures shall be given, and the creditors shall agree among themselves which creditor will comply with the requirements that this part imposes on any or all of them. If there is more than one consumer, the creditors may be made to any consumer who is primarily liable on the obligation. Letter G, effective subsequent events. Number 1, approval disclosures. If the disclosures under 1026.47B becomes inaccurate because of an event that occurs after the creditor delivers the required disclosures, the inaccuracy is not a violation of Reg Z, although new disclosures will be required under 1026.48C. Final disclosures. Number 2, under letter G, effective subsequent events. If a disclosure under 1026.47C becomes inaccurate because of an event that occurs after the creditor delivers the required disclosures, the inaccuracy is not a violation of Reg Z. I'm going to just break before going in the content of disclosures, about halfway through this section about private education.